Good afternoon, everybody. My name is Chris Justice. I am a senior associate with Samfiru, Tumarkin. I work out of the Toronto offices, as many of you may know. And as always, I'm here today to join everyone in hopes of answering as many employment law related questions as I can. So do get your questions in. It could be anything. It could be something you're wondering about on your way into an employment situation or working relationship. Maybe you're experiencing some issues during the work experience itself, or perhaps you've lost your job, or you've got a question on your way out or on an exit from the company. But as I say, whatever it is, get your questions in, and I'll be spending the next half hour or so answering as many of those as I can. As I normally do, though, I like to start off by just talking about some things that are going on in the news or some topics in general that deal with pretty common employment law related issues. In this particular case today, I was going to start with some news as far as there being a number of layoffs, a number of job cuts that have been happening across many industries. And this has been going on for quite some time now. And in the news, there are still stories every day of, mass layoffs happening, terminations happening, severance packages being offered to people. And so if you're somebody who has been let go, whether it's part of a mass termination, a big group of people that are being let go at the same time, or maybe you're just being let go yourself, there's a good chance that you're probably being presented with a severance offer of some sort. And a lot of times people may not know, but they'll look at the severance offer. It'll say something along the lines of you being given more than just your bare minimum entitlements. And unfortunately, a lot of people read this and think that it's therefore a reasonable package, that the company is giving me both my bare minimum entitlements on the one hand, and then offering me, an extra chunk of money as long as I sign the full and final release. And I wanted to actually talk about some of the main issues or the main questions that center around termination packages. And so if you're somebody who's received a severance package, maybe some of these questions or issues have come up in your mind. And so that's what I'm going to try to address at the outset of today's session. So the first thing I wanted to talk about actually had to do with deadlines being given in severance packages. So you're given a severance package, let's say on a Monday, and the severance package says that if you return the signed release of the companies within a week, they'll give you more money. And if you don't return the signed release to the company within that week, or maybe sometimes 2 weeks, that they're going to just pay you the bare minimum amount of severance, and that's it. And a lot of people come to lawyers at our firm, and they're worried because that deadline is coming up, or maybe they've missed the deadline, and they feel pressure to sign the package because they think that if they don't sign the package by the deadline that's put in the letter, that they're going to forever forfeit any additional money that could be coming their way. And what people need to understand is that this is just not the case. The deadline is nothing to worry about. The deadline is primarily there just to put you under some pressure, to get you to sign that release, because more than anything, that company wants that signed release so they have the peace of mind to know that you're not going to be coming after them later on. They don't have to look over their shoulder wondering if you're going to be seeking further compensation from them. And so they very much want your signed release. And again, that's why they put a lot of pressure on people to have the release signed within a certain time frame. But when I look at these severance packages, the vast majority of them are simply well below what somebody is actually entitled to. And the vast majority of times I'm telling people, do not sign that release. Don't sign the release in a week. Don't sign that release a month from now. Just don't sign it, because you deserve more money and you should be negotiating and trying to get more money. And so in that sense, if I tell somebody that they need to try to negotiate a better package, or I do that on their behalf, what I'm doing is I'm going to present the company with a counter offer. So let's say I think my client's owed, a year of severance, but they've only been given 6 months or offered 6 months. I'm going to tell my client to reject that 6-month offer, and that we should go after them, let's say, for a year of severance. And when we reject the offer technically comes off the table in any case, because we're going after more money. But very quickly that original offer of the company sort of gets forgotten. It goes by the wayside, and that deadline becomes a forgotten thing as well. So don't worry if there's a deadline in your severance package to think that if you don't comply with the deadline, you're out of luck, that you're not going to get more severance. That's just not the case. And you certainly shouldn't be signing a full and final release just based on the deadline alone. You want to get some legal advice. You want to talk to a lawyer, and at the very least, get that information first before signing anything. Because it's highly unlikely that just because you're even a few days late or a week late or whatever it is past the deadline, very unlikely the company's going to just forfeit what they initially offered you. And as I say, in most cases, you're going to want to pursue more than just that. So don't worry about the deadlines, but do try and get some legal advice sooner rather than later. And at that point, the lawyer can oftentimes take over, and that becomes a forgotten thing, as I say. So that's number one, is the deadlines that I see in these severance packages. Number two, a lot of times when you are let go from your job and you're given a severance package, you're given a letter, and it'll say something like, so-and-so, we're informing you that we're letting you go without cause due to restructuring or due to a reorganization or something along those lines. And then it says what the company is going to offer you. And maybe the company gives you a few weeks, a few months, whatever it is. But there are some cases where the termination letter itself will mention an employment agreement or employment contract that you signed maybe in the past year or going years back. Something where it'll say, we looked at your employment agreement that you signed in 2018, and it says that we owe you this amount of money, so we're going to give you this amount of money. And it's important to know what agreement they're talking about. So if you have a termination letter and it's referring to some sort of a contract or an employment agreement that you signed, it's good to get a copy of that if you don't have it, because that's likely going to be partly the reason why the company has offered you the severance that it did. And it is possible, if depending on what the contract says, that your severance entitlements could be affected. So the wording in the contract, especially around termination, could be the difference between somebody maybe getting 8 weeks versus 8 months, or 10 weeks versus 10 months. So the contract can be very influential, can be very significant. So again, if you have a contract and it's being even referred to in your termination letter, you want to make sure you get a copy of that, you have a copy of that, and also get some legal advice on the contract. Because in most cases, when I look at contracts, I find that they're not really a problem as far as the employee is concerned. I find that they're not drafted as well as they need to be. And in most cases, those contracts aren't even enforced by the courts. So it's almost as though it doesn't exist, which then leaves open the potential for you to get way more severance. But then there are a small amount of cases where someone will have a contract and where that will actually significantly affect somebody's severance entitlements. So you want to make sure, like I say, you've got the contract and you get some legal advice on that too when you come to the lawyer with your severance package, with your severance offer. Another thing I wanted to talk about when it comes to severance packages or offers that you get in letters is sometimes the offer of severance will be given to you in one big lump sum. And then other times the severance offer will be stretched out over a period of weeks or months, where the company just puts you on a salary continuation model. So they just, keep you on payroll for every 2 weeks and pay you. And so there's different structures that these severance packages can have. And depending on your situation, you may prefer a lump sum payment, or you may prefer the money to be stretched out or paid in installments. But that's also something that's potentially negotiable as well. So don't feel as though you're kind of stuck to a certain style or structure of payment when it comes to severance. There could be, like I say, multiple structures depending on your needs and depending on what you're able to negotiate with the employer. I'll get into some other, main issues or topics when it comes to severance packages if we've got some time. I just want to get to some of the questions that have been posed. I've got one question from Bill on Facebook, and Bill is saying that they've been working somewhere for 14 years. What's the vacation entitlement after the 6th year under the Employment Standards Act? And what should I do if my employer refuses to pay me the correct percentage? So typically everyone will start with 2 weeks of vacation at 4% vacation pay. And after actually 5 years, it will go up to 3 weeks of vacation at 6% vacation pay. And that's just what the Employment Standards Act sets out. But depending on your situation, you could actually have in your contract a greater vacation percentage. Sometimes I'll look at contracts and it'll say that somebody's owed, 10 weeks of vacation per year, or 10% vacation pay, or 6 weeks vacation at 8% or 12%. So the percentages can vary, but at the very least, usually it's minimum 4 to 6%. And if your employer refuses to pay you the correct percentage of vacation pay, then that's going to be a huge issue, because that's what the employment legislation guarantees for individuals, is that they receive at minimum a certain vacation percentage based on the wages they make throughout the course of the year, or for however long they're working at the company. And so by not paying the correct percentage, there's then a violation of the Employment Standards Act, which you could then get legal advice on and pursue in a legal fashion, either with the help of a lawyer or also potentially through the Ministry of Labor. Although my suggestion would be to contact a lawyer first before going down the ministry route. But yeah, that could be definitely a big problem, violation of vacation pay. And by not paying someone the correct vacation pay, that could also easily amount to a constructive dismissal. So when I've got a contract with my employer, or I've got certain rights under the law, and my employer violates that contract or violates those rights, and I'm still working there, and I've told them that I'm not accepting this violation and that this needs to be fixed, but they're just not doing anything, then I myself as the employee may have the opportunity to basically leave that employment situation, pretend as though almost I was terminated by virtue of my company failing to give me the correct vacation pay percentage. And then not only go after that vacation pay, not only go after potential damages for violating the legislation, but also treat it as a termination and go after the company for my full severance pay. So it would be almost in a way, a forced resignation, where I'm being pushed out as a result of this violation. And then I'm going to go after all these different avenues of compensation, which can be quite expensive for the employer, depending on where you work. And if you're at a company for 14 years, you could get, for all I know, a year and a half of severance for that violation based on the constructive dismissal, plus, your vacation pay, plus potential other damages. So I think first I tell people to object to the issue, put their voice in writing as far as what you're looking for, what the issue is when it comes to vacation pay, and sort of if you can crunch the numbers, that would help. And if in spite of doing that, you're still being dismissed or it's just being brushed under the rug, then at that point, I think something more needs to happen, and you need to get some legal advice. And as I say, potentially go after the company for all those different heads of damages. But thanks, Bill, for the question. I think it was an important one. I do have that come up a lot, where people are sort of getting screwed out of their vacation pay or their vacation time. So it can become an issue for sure. I've got another question in from Arthur M., who's asking if I work for a US-based company in Canada. That's not true. I work for a Canadian company. So we don't model ourselves on anything relating to US laws. And entitlements when it comes to severance and employment law related matters are also very different if we're looking at Canada versus US. In many ways, US laws are much less forgiving than Canadian laws. But what we do at our firm is with respect to Canadian laws. So as far as any questions regarding US laws or US employment law matters, that just won't be something I'll be able to help out with. I've got another question in from Keith on YouTube, who's saying that they were let go recently with cause, but the cause was not specified, and that they had to chase down HR to get a reason. And even then it wasn't specific. And then the question is, are employers legally obligated to give a reason, excuse me, at termination? And Keith, in most cases, they don't really have to give much of a reason, if any, especially on a without cause basis. But when it comes to cause, there is going to be more of an onus and obligation on companies to provide the reasoning for the termination, because normally when you're let go without cause, or with cause rather, you are not given any severance, or you're given very little severance, if that. And for cause terminations are considered the capital punishment of the employment law world. They're very rare. It's very rare that they actually succeed. And so a lot of times I will have companies allege cause and say that a client of mine, for example, has been let go for cause, but then there actually isn't cause, that either there's no cause whatsoever or the reasonings for the termination do not rise to the level of a cause termination, in which case there's full severance owed. And actually, employers can get into a bit of hot water when they make allegations of cause, when there's no merit to those allegations. They can be exposed to additional damages for that bad faith accusation. Because again, just being told you're being let go for cause and having that reflected on your record not only means no severance, but it could also affect your ability to get EI. It could affect your ability to get another job. So there's a lot of problems when employers allege cause but actually can't make it out. And Keith, it sounds like they don't really have much of a reason or specifics on why they let you go. So my alarm bells are sort of going off in the sense of, why is it that they let you go? How severe of a punishment are you getting by virtue of this cause termination? And I think especially if you've been there for quite a while, the potential for you could be quite large. There may be a bit of a battle with the company until we figure out what the cause is. But like I say, most of these cases I find there is no cause, and my client or the individual is owed, usually significant amounts of severance, not to mention potentially other damages. So this would be one to give us a call about, Keith. Get in touch with our firm. We can have a consultation. We can kind of go through the specifics with you and figure out what exactly is going on, whether you signed a contract beforehand or not. I mentioned at the outset of the show today that contracts could be relevant factor as far as what you could get on your way out. But yeah, definitely give us a call, because it sounds like there's a good chance you'll be owed a lot more than whatever it is you're getting, if you're getting something. But appreciate your question. I've got another question in from Nick on YouTube, who's saying that in 2022, a company that he worked for got bought out by a corporation, American corporation, and that at that time the duties and responsibilities had changed greatly. And now the job that Nick has is essentially a different job altogether. And he's saying that this happened in November of 2022. So first of all, usually when big changes happen to your job or to anyone's job, what I tell people is to note those changes down in writing. As soon as you come into a job and a bunch of changes happen, let's say I'm a lawyer and in 2022, my company comes to me and says, now you're going to be a janitor, just to use an extreme example. I want to put in writing, number one, the fact that these changes are happening. I want to spell out, if I can, what my job was before and now what it is after. So I can kind of give that before and after picture that to show this black and white. And then also if my actual title has changed, that would be another thing I highlight. If my pay has changed or my location has changed, that's another thing I'd want to highlight. But basically, I'd want to try to highlight all the changes I can to show that they are, in fact, significant. And then I also want to make sure that I mention that I'm not open or agreeable to these changes. So you want to highlight the changes on one hand and make sure that they understand that black and white picture. And then on the other hand, you want to be clear that you're saying that you object to these changes, that you're not sort of condoning them, that you're not accepting them, because otherwise they can just then form a part of your employment relationship and it'll be that much harder later on to go back after the fact. So putting it in writing, your objection, stating that it's a significant change and, providing the basis for that, that's definitely one thing I do recommend to people when they have these issues. And then depending on what the company's response is to that, maybe things change and they get better, which is great. Or maybe the company provide some sort of a justification, which I'd have to look at, or perhaps the company just says that your job is not going to go back to how it was and that all these changes are going to continue on. But at least now you've got that company's response, you've got their position, so that if you come to a lawyer at that point and are thinking about leaving, you're going to have a better shot of leaving and going after them for constructive dismissal versus a situation where you never raise these issues with the company or put anything in writing and then just leave out of the blue from their perspective. It can be a bit more difficult to go after constructive dismissal when there isn't that groundwork that's been laid beforehand. But absolutely, Nick, you're asking if this qualifies for constructive dismissal. Yes, if there are significant changes made to the duties and responsibilities that you don't condone or accept and have sort of objected to in the past, then you want to make that known to the company. And if they don't want to change, then at least you can show you've done everything you can. And if a lawyer needs to step in at that point and sort of state that there's been a constructive dismissal or make that allegation, the lawyer will have a better job of doing that and getting you compensation to sort of fit whatever your circumstances are. But this also looks like something you'd want to give us a shout about, Nick, because if it's been going on since 2022, there's probably a lot of information to sort of relay, and I'd need to know exactly what your communication has been with HR. I know you've said you've tried to contact them in terms of renegotiating compensation and job and everything like that. So again, it would just be a question of, is this in writing? How have they responded if all in writing? And before you leave or give a resignation letter or anything like that, or claim constructive dismissal, give us a shout so that we can at least also guide you through that process, so you're not saying or doing something that might, as I said before, kind of make it more difficult for you to pursue that angle. But I do appreciate you reaching out, Nick. So thanks for that. I've got another question from Bren on YouTube, who's asking whether or not there are situations where an employer can refuse to bring you back from medical leave of absence. And generally speaking, there isn't. The employer would have to show that to bring you back, that would constitute an undue hardship that the company simply could not accommodate. So in most cases, if somebody is coming back from a medical leave of absence, they're either coming back with their full job back, no restrictions, in which case, their job typically has to be kept open. And if it's not available for them on the return, that can be a huge problem for employers and potentially involve human rights issues. Or there's another situation where an employee will be ready to come back, but there'll be limitations or restrictions. And the question will then come down to, what are those limitations and restrictions? Because employers do have to accommodate up until the point of undue hardship, but there is still a limit depending on the situation that the employer has to accommodate for. So if, for instance, you work for a small mom and pop shop, let's say they don't have a lot of money, and in order for you to come back and have your restrictions or modifications sort of adhered to, like let's say it just requires the company to spend $1 million, it's an extreme example, then the company could potentially likely claim undue hardship. But if you coming back from a medical leave only involves your employer making, let's say more minor accommodations, maybe they got to get you an ergonomic chair, or they got to allow you to, take a seat for every half hour or something. I mean, there could be a whole number of different types of limitations or restrictions. That's not probably going to be enough for the employer to say, oh, we don't want you back then. Your employer would have to show that the cost would be very significant, relatively speaking, to have you come back, or that by having you come back, you're not going to be able to do your job. Because there's other scenarios where individuals are ready to come back from their, say, medical leave of absence, but they can only do 20% of the job they had before they went off on the medical leave. And so that might be a situation where an employer can refuse to have that person come back until they're able to do more of their job. And then there's other scenarios where people can come back from medical leave and do 90% of their job and are legitimately supposed to be accommodated. And yet they find out from the employer that unless they can come back at 100%, not 99, not 95, but 100, that the employer doesn't want them back from their medical leave of absence. And then that's when you get into more of a situation of the employer being unreasonable, because even if there is some inconvenience, even if there is some form of accommodation that the employer might find, not ideal, that's not going to be generally good enough to refuse you to come back. And again, you then open up a can of worms as far as, human rights considerations and all that kind of stuff. But yeah, normally employees ready to come back, the employer has to cooperate with that return, maybe work a little bit with the employee's doctor if there's are certain limitations or restrictions. And even if it's a gradual return, that's typically something that's expected of the employer. So if there's any resistance, I guess, Bren, that would be in more of the unreasonable category to your perspective or view, you may want to give us a call. And again, maybe just like Nick, we can kind of guide you through the process in terms of communicating with your employer return, in terms of maybe giving certain medical information to your employer. Because another situation that comes up with medical leaves is the employer is asking for a bunch of information from your doctor that they're actually not entitled to. They're looking for, what your diagnosis is. They're looking for what medication you're on. And they just look for a whole host of things that again, they're not entitled to. And as an employee, you want to give them just the absolute bare necessity as far as the information the employer needs to accommodate a return if they need to. So definitely before divulging, especially more private medical related issues or details, you want to kind of give us a shout too, so that we can kind of manage the exchange of information there. Because another issue is they won't have you come back until you provide certain medical info that they want. But if they're not actually entitled to the medical information, then it's not a valid reason for denying you to come back too. So that could be another problem. But definitely give us a call, Brent. I'm sure we can kind of go in a bit deeper on your situation and flesh it out. I've got another question in from Christiana on YouTube, who's asking if our firm helps unionized employees. And unfortunately, no. Our firm specializes in non-unionized matters. For the most part anyways. I've had people contact me in the past that are part of unions that need help. And usually, for what it's worth, even though I'm not a unionized employment lawyer, I will tell them in general that they need to either refer to their collective bargaining agreement, which often will apply in these cases, and or also contact their union rep. The union rep is usually that go-to that they're going to be able to connect with. So if you're a unionized employee and you're thinking of, let's say, filing a grievance on behalf of, on behalf of the company or the union, talk to your local union rep. The grievance process is usually set out in the collective bargaining agreement as well. And you have to generally go through that avenue before a lawyer can potentially step in and maybe take over from there. I've got another question in from somebody, things we like to do on YouTube, who's stating that we represent this individual, and they have discovered some other former employees that have done the same thing. So sorry, I don't know what you're referring to on this, but if you're mentioning that you've got a case with us and you've discovered other employees that may have had their rights limited or curtailed or affected in some way similar to you, and there's a potential case to be had, then definitely, we always accept referrals. And this applies to anyone there. If you're in a situation, if it has to do with, let's say, a termination, or maybe you're getting harassed at the workplace, or maybe you're in the same boat that a number of people are in when it comes to whatever employment situation you're in, and you think that they could benefit from having legal advice given just as you did, then definitely refer them our way. I've had a lot of cases where I've represented people and they've told me that other people are in a similar boat. And I just usually say, have them contact our office. And in some cases, it makes sense to streamline it all and deal with the same lawyers because the matters have overlapping sort of interests or issues. But either way, definitely refer things our way. And if we can be of help, then I think we absolutely will be, and always appreciate referrals from everyone regardless. So thanks for that. I've got another question in from JX on YouTube, who's saying whether or not our firm represents union locals when bargaining with employers. And no, that's also, to my knowledge, not something we particularize in. Again, if you want to look for unionized matters in terms of collective bargaining and all that, at the first point, you can go to the Law Society of Ontario. They have a lawyer referral service that I'll suggest right off the top. They may be able to point you in the direction of someone who could assist. I've got another question in from Bree on YouTube, who's saying that they're unable to do on-call work that their employer is implementing, and they have medical reasons, and they provided a doctor's note, and they're asking whether the employer can let them go because of this, and if the employer is legally allowed to do this. So if your employer is changing things up, or the nature of the work requires you to be on call, and you actually have a valid medical reason for not being able to do that work, then going back to what I was saying earlier, as far as accommodation, your employer has to generally accommodate those issues. Even if it's not ideal, even if it means you're going to be maybe treated somewhat differently than other people, if you've got that valid medical reason, doctor's note, there should generally be no reason why the employer would insist on you doing the work. And if the employer does insist, like I say, that could be a violation of human rights. If the employer lets you go because of this, that could also be a violation of human rights, because the whole issue is, if it weren't for the fact that you had a medical reason for not being able to do it, the employer wouldn't have let you go. And that's where the connection happens. And that's where the violation of the human rights happens. And that's where, the employer then gets into stuff that they're not legally allowed to do, which could result in you getting your full severance, getting your human rights damages as well, plus potentially other bad faith damages. So if you're in a situation like that, you've given your employer a medical note backing your inability to do certain work, and they're insisting that you do it or otherwise threatening your job, give us a shout right away, because that could be a very serious situation. And depending on how long you were at the company, you could be owed quite a substantial amount of money. And at the very least, it would be just good to know what your options are so that you can make the best informed decision possible moving forward. But having said that, though, that's going to be my time for today, everyone. Again, I do thank everyone for the questions. Hope you enjoyed today's session. There'll definitely be future sessions when it comes to employment law stuff, so be on the lookout for that. As far as disability employment law is concerned, you see down below there with Martin Willems this Tuesday. So that's tomorrow at 10 o'clock Pacific for those that have some disability law questions. But for today, that's my time. I'll be signing out. Again, thanks for everyone joining us, and I'll definitely be back in the near future. Do take care. Bye for now.